Anyway, I'm all mic'd up now, so thank you. Yeah, we've only got one slide actually. So for those that, well, most of you I've not met, Lee Bacon, partner in the international law firm Clyde & Co. We're focused on insurance. I'm here with my partner Nigel, so we bought the drinks effectively. Thanks, Adam. Thanks for that introduction. We'll both be here to chat now, but we thought in the interest of time we'd strip it down, and I'll just spend a few minutes talking to you from our perspective. And Michael, you were asking how do you know that this thing is working? I guess the fact that we're here, I mean, we're following as a service provider to the insurance market, we're here. So I think that's an indication that it's beginning to work. And I'll start with a confession. I'm a bit of a technophobe. I was reflecting on the way over. In my briefcase, I have a moleskin notebook, a pen, paperback book, actually Tales from Ovid, this kind of Roman mythology. I've got a BlackBerry in my pocket, which my 17-year-old niece assures me is the lamest phone in the world. But anyway, so we're there. But what's our interest in this is really looking at the fundamentals of, or the potential fundamental impact that blockchain and associated technologies may have kind of on the structure of insurance and insurance products. Sorry, I'm standing right in the middle of here. So, and looking at it, I'm going to look at it really from a disputes perspective. For those that don't know the insurance market very well, it's been, frankly, a good industry for its lawyers and other service providers because it's always been prone to disputes. Perhaps has a worse reputation than it deserves, but I think it's quite a good kind of construct to have a look at the market because it gives you an idea of some of the fault lines that within the market and some of the inefficiencies within the market. So we're going to have a very brief look, kind of looking through the mist as to why things are done and how things are done and what potentially you can learn from kind of our experience and where we see some of the developments coming. So I'm going to put down a couple of my old school books. So, just really looking at three relevant themes. Disintermediation, I'm glad I pronounced that correctly, I was worried about that one on the way over. A huge number of disputes in the insurance market simply arise out of the kind of the web of relationships. Michael, you showed the slide here in terms of Tom and what the market may look like. It's been a huge source of dispute within the market and therefore inefficiency, essentially. Good for us at times, but not necessarily good for the market. Broker to insured, broker to insurer, insured to insurer, reinsured to reinsurer, cover holder, for those not familiar, when insurers delegate authority under binding arrangements or what have you to the insurers. And that's before we even begin to think about the layer upon layer of retrocessions. And within that, you've effectively got a whole webs and chains of communication. What sort of breakdowns occur? Delays essentially in communication, late notice. If you look at any standard insurance law textbook, there'll be a whole chunk on notification issues, both before a policy is incepted and afterwards. Give you one example. I had a case, I was reminded because we had a mediation in this building concerning the provision of information to an underwriter providing casualty cover in North America for windstorm damage. He was given a whole 5-year loss record. You know, this is the loss record for the past 5 years. He thought it was actual loss record for that 5 years. It was model data. It was as if stripping out certain risks, stripping out the bad risks, obviously. The only way he was told it was as if, it was in a little footer to the document, which was fine. The footer was only visible when you printed out this 150-page spreadsheet, which of course he never did and didn't happen. So we had quite a lot of fun dealing with whether that constituted, and this is the legal test, a fair presentation of the risk. So I mean, interesting and fun for us and kind of created some new law, but in terms of an inefficiency within the market, an obvious example of the problems that can arise. And I think within that, again, just different expectations. Same client actually, I'll give you an example of a similar case. They thought on a reinsurance arrangement, so again, I forget the nature of it, property risk across North America. They thought they were reinsuring 50% of 50%. Turned out they were reinsuring 50% of 100%. It just hadn't been very clearly drafted in the policy wording. So again, there's a clear opportunity there for the utilization of technology to strip out those inefficiencies. So second, very, very conscious of the time, smart contracts. I'm going to tread very carefully here. I think the very phrase smart contract can be unhelpful. It's kind of mixing old school or traditional terminology with context in where it may not be helpful. Certainly in terms of how the regulation works now, for me, the exciting prospect with the technology is in the execution, and you're probably going to have some kind of wraparound contract there. As I said, most of the issues really there are in execution, especially the case in an industry which is built around sharing, syndicated risk sharing, excess lines, reinsurance, retrocession. All goes back to what I was saying before. The possibilities for disputes and lack of communication or miscommunication are ripe, and I think there's a real prospect for the technology to strip away some of that. So I'm not really going to talk about that in detail. I think I'm not sure that a lot of the smart contracts are in fact contracts as the law would call them, but I think that's a topic for another day. And then again, finally, just talking about DAOs, how the law might respond to these, how it might treat these. It's an interesting legal challenge. Clients always hate it when you say, well, this is an interesting legal challenge, because that generally means it's going to be an expensive exercise for them. Who's responsible for them? Is that in itself a wrong question? Do they have a separate legal entity? Are they owned in common or owned by no one? These are pretty fundamental concepts for something which may be reliant upon information within those structures. So there's a lot of work to do there. I don't really have any answers here. My view is that most likely insurers or brokers looking for a space within this communication will be looking to maintain them. But again, there are just fundamental legal issues there that need to be borne in mind. English law has taken a couple of hundred years to refine the duties of brokers and loss adjusters, who are typically owe duties to more than one counterparty, not dissimilar in principle once you strip away all the technical surroundings to this sort of thing where you have a decentralized system. So, and I'm not even going to touch upon what law and jurisdiction might apply to one of these organizations. The standard test, certainly under EU law, is the place of performance of the contract. Where's the place of performance of a DAO? It's a very interesting discussion. And then finally, just to finish on one very concrete example, which Nigel has first-hand experience of, and we'll talk to, the Tianjin explosion at the port, which I believe was last year, for Nigel for confirmation. Huge explosion, and the insurance industry ended up with billions of dollars of exposure and unexpected exposures, just because they didn't have a way of properly monitoring their accumulation of risk really within the supply chain. So again, if you've got an Internet of Things solution to that, so you know where everything is, and at one time you can at least monitor your accumulation and can strip out inefficiencies in the market as well. So I'm very conscious of the time. That's a very quick run through of some issues. Probably more questions than answers, but that's how we like it. But as I said, if we've got a minute for questions, or Nigel and I will be here later as well. So.
Questions?
I can just hear you, I think.
Go ahead.
Hi, I'm Jean-Pierre Delta President. I have a question for you in terms of also, have you looked at being able to send messages back? Let's say, one of the things is, if you have the item, it's sitting in a place, and you know weather is going to be bad, have you also thought, let's say for a car, it's going to be a hailstorm. So advising, messaging your insurers, the people you're insuring, that this is going to happen in order to reduce the events?
I haven't. I suspect Nigel might have done. He's done a lot of work on kind of autonomous driving, driverless cars. But it's an interesting concept, because insurance contracts, unlike general insurance contracts, are built on good faith, which generally requires disclosure from and mitigation of risk by an insured. But that sort of concept, what duty is on an insurer to inform its insured about his issues, and if it fails to do that, and with the time of that. So I'll be frank, I haven't looked at it, but well, it may be an added benefit, but then from a legal perspective, you immediately begin to think, well, when was it reasonable for them to do it, and when did they not do it? And it could potentially be a failure within that scheme. So again, that's probably answering a question with a question, but it does raise fundamental questions in terms of the structure of insurance contracts as they are now. And I suspect you may want to have a word with Nigel afterwards, who's there. Great.
Thanks a lot, Lee.
Super. Thank you.
Yeah, thanks for the insight.